The force majeure clause. So rather than claiming impediment beyond control after the event, what parties are much more likely to do is enter into a force majeure agreement, including a force majeure contract clause within their contract. Now, force majeure is a French term meaning essentially superior force. And it is a contract clause that excuses a party from failing to perform in the event of certain specified items, like a war, or blockade, or fire, or strike. And by including these terms within the contract, a party can not perform, they can fail to perform, but they have not breached the contract because they are complying with the force majeure clause. Now, courts don't like to release parties from a contract on the basis of an excuse. In this case, however, the excuse is within the contract, and thus the party that did not perform can claim that they are still in compliance with the contract. So rather than waiting until after the event occurs and we start to argue that war or blockade or fire or strike or pandemic was unforeseeable, was an impediment beyond control, instead we can include those elements into our contract. So force majeure is what we call a contractual remedy, a contractual defense, meaning the defense is contained within the contract. Impediment beyond control is what we call an extra contractual defense, a defense outside of the contract, and therefore much harder to establish. So I've included a sample force majeure clause on Canvas. Go take a look at that. These clauses can become very important. We saw right now there are thousands of lawsuits involving force majeure in which there are claims brought because of the pandemic, because of shutdown caused by the pandemic or business that was interrupted by the pandemic, and then looking to see whether there is an element in their contract that excuses a party from performance. And what I guarantee you, in every force majeure clause from now on out, there's going to be a provision for a pandemic or an epidemic or a virus or any of those things. Governmental approval clause, another special type of force majeure clause. Oftentimes we need government permission to transact business across international borders, meaning if the United States imposes sanctions on another country, well, sanctions are really not directed at the other country. They're directed at residents within the country that has imposed the sanctions. So when we say a company, the United States has imposed sanctions against Russia, that is really a sanction against American companies from selling products to a buyer in Russia. Therefore, because the government has said that's not possible to comply, we can include in our contract a governmental approval clause, which is a special type of force majeure. Superior force, in this case, being governmental action. The alternative to using a force majeure clause is to argue impossibility or impediment beyond control. But again, by using force majeure, the non-performing party is complying with contractual terms and thus does not breach the agreement. So, in international sales contracts, the parties greatly favor the use of a force majeure clause. If the thing that happens is outside the scope of the force majeure, then the non-performing party can claim impossibility, or impediment beyond control. Hopefully, you and the other party have included every potential occurrence within the force majeure clause. So in conclusion, what did we learn? The law defines damages, monetary damages, as the money claimed by or ordered to be paid to a person as compensation for loss or injury. There are these three components to monetary damages: compensatory, incidental, and consequential damages. And then finally, we know that damages can be calculated based on the party's expectation interest. If you have any questions about any of this, and this is a very complicated area, feel free to reach out and ask. Thanks a lot.